exactly does it mean when someone tells you to trust the process? Is it an excuse because they don't have the answer? Or is there something more to it? Now, in order to trust the process, there has to be a process. And what process are we talking about? I'm Rizzuto, a trial attorney representing victims of personal injury and nursing home neglect, as well as other types of matters. Trusting the process is a conversation I have frequently with many of my clients. When most people come to me, they've never had any experience with a lawyer, they've never had any experience with personal injuries or any sort of neglect or pain and suffering, and they have no idea what to expect. But there is a legal process. It is long, it is hard, and it is frustrating. And regardless of the case they come to us with, it is impossible to determine the outcome at the initial meeting. Right? These cases are a process. The legal system is a process. Our law firm has a process in moving these cases. So initially, when a client retains us, we complete the initial paperwork, which usually consists of a medical record authorizations, a client engagement letter. Sometimes we have to put Medicare or Medicaid on notice, and hence the process begins. Initially, we notify the party who caused the injury and put them on notice of a potential claim. We request that they forward our letter to their insurance carrier, because the insurance carrier is the one with the money who we need to engage with. We start sending out for medical records or any records that support our client's claim, especially when it comes to the injuries or the damages that we're claiming. If after about 2 weeks to 30 days we do not hear from the party who we sent the claim letter to or their insurance company, we will send a second letter. Again, asking them to put their insurance company on notice and to contact us so we can begin our discussions. Once we hear from the insurance company, we let them know what the claim is about. We start assembling our evidence in order to send it to them so we can try and resolve the case without having to go to litigation. Oh, you want to know what happens if we don't hear from the insurance company? That's a different process. What we will do is we will send a final letter. Sometimes we'll actually draft a summons and complaint and send it to the person we're making the claim against or the company. And we will tell them that if we do not hear back from them within 2 weeks to 30 days, we will start a lawsuit. And we do. Once we start the lawsuit, if we don't have an answer, we make a motion for a default judgment. Once we are successful with getting a default judgment, then we move on to what's called an inquest to determine what the damages are and what the client should be awarded. However, that's relatively rare. In most cases, the insurance company will engage and we will begin a dialogue. The process entails us getting the medical records or proof of damage or proof of the claim. We put them together in a package, which we refer to as a specials package, and we send it to the adjuster. Then we wait for the adjuster to review those records and our allegations. Depending on the adjuster and the insurance company, that could take a couple of weeks to sometimes a couple of months. But remember, this is all about trusting the process. So sometimes waiting a couple of months is okay if it could avoid you years of litigation. The key is to keep in contact with the adjusters, remind them you're interested in having a discussion, and trying to pin them down into a time frame when they will have an opportunity to review the records and be prepared to discuss the case. If we are in a situation where we have to file a summons and complaint due to time constraints, then we absolutely do so. Once the adjuster has our records, they have an opportunity to review the file, we begin a dialogue. Shortly thereafter, we will know whether or not we're able to resolve the case or whether we have to proceed to litigation. This process usually takes about 10 months. Sometimes it's shorter, sometimes it's longer. Once we have to file a summons and complaint, that is a completely different story. That process can take several years. Once a summons and complaint is served, the party who's being sued usually has 20 to 30 days to put in an answer. Sometimes they will contact us and request more time. In most situations, we will provide it as a courtesy. However, we do request they waive certain defenses, such as jurisdiction and improper service. Some clients get it, some clients don't. We recently had a situation where we were retained by the clients in November. We had a lot of preliminary things that had to get done before we could even consider filing a lawsuit. Those things were done by the end of December. In this particular case, I dropped everything to make sure we got done what needed to be done. As January came, I told the client we would be ready to start the lawsuit, and we would probably be filing the claim in late February, early March. During that time period, the paralegal handling the matter got COVID. I began a trial, and the summons and complaint did not get filed as quickly as I intended. It filed by the end of March, which is still pretty damn quick. And in the middle of April, I got a really nasty email from the client wanting to know what's going on and why am I not keeping them informed. I had to reiterate the whole history to the client. And basically, there was not more than 2 weeks that went by that we were not working on this file. And what had to be done immediately was absolutely done, and done to perfection. I had to tell her to, quote, trust the process, unquote. And then I had to explain to them what the process is. Like I said earlier, most clients never been involved in this and they do not know. We were suing multiple defendants in this situation, and they needed to have an opportunity to file an answer to the complaint. And as most defendants do, they will request an extension of their time to answer, which again, we generally will give. Once they answer, we have to serve certain documents detailing all the allegations of our claim and giving them information that they can obtain so they can review our allegations themselves. Now, as part of the process, we need to get the court involved. So generally, when we get the defendant's answer in a claim, we will file what's called a request for judicial intervention, meaning, court, please get us involved, get us on your calendar, and let's keep things moving along. Hence, another process begins. Different counties have different processes and different time frames in order to complete those processes. So generally, from 60 to 90 days from filing the request for judicial intervention, we will get a conference. At that conference, we will set a timetable to complete discovery. What is discovery? Discovery is where both parties exchange information so we can see what each other has regarding the strengths of the case and the weaknesses of the case. Part of that process is depositions. Depositions is where the parties appear at court or one of the attorney's office or a court reporting agency and tell their side of the story. They answer questions by the attorneys for the other side, and they provide information regarding the claim. Part of the process involves the court having conferences to check in on the status of the case. How's it going? Is it moving along? And if it's not, you better get it moving, because the court's going to get upset and there are going to be consequences to whoever is stalling. Once we complete the discovery process, a document called a note of issue is filed, which places the case on the trial calendar. Again, depending on the county, will depend on how long the case will remain on the trial calendar. But during that time period, it could be a year and a half to 2 years. Now during COVID, sometimes it's longer. But once the case is on the trial calendar, another process begins. The court will have a pre-trial conference. They will try to have settlement conferences, and maybe the parties may have discussions about going to private mediation in order to resolve the case. We get calls from clients all the time while the case is on the trial calendar. What is going on with my case? Are you ignoring us? What is happening? When will my case be over? And the conversation I have to have with them is, this is a process. We have to trust the process. There is so much that we can do as attorneys to move your case along, and whatever can be done, we do. We do. I will typically send out a letter to the defendants and or their insurance carrier requesting to go to mediation at a point where I think the case could settle and they have enough information to have evaluated the case. Especially during COVID, nobody really knew what the process was. So it was somewhat more difficult to trust, and somewhat more difficult to convince a client to trust the process. But overall, you have to do it because it is a process. And in my experience, the process works. Now, once you come to the realization that the case cannot be resolved or settled, you will start getting on the trial calendar and you will be called into court. Again, different counties work differently. But once you get nearer, there is a process for the trial. It starts with jury selection, then you get assigned to a judge, Then there are conferences involved trying to settle the case again and to talk about scheduling. What witnesses are the parties going to call? What experts are they going to bring in? What is the proof that's going to be offered? And when is this all going to take place? A lot of it is outside the attorney's control because we don't know who the judge is. We don't know what the judge's schedule is. So it is very difficult to schedule our clients or our expert witnesses or to get the evidence in the court without knowing who the judge will be and what the judge's schedule will be. And it can be frustrating. It can be frustrating for you as a client because you've never been through this before and you have me or whoever's representing you telling you this is a process, we have to trust it. And the trial process is something I speak to the jurors about during jury selection. I tell them what to expect at the trial. I tell them what I will prove as the party representing the plaintiff's case. Where I'm actually defending someone, I will tell them what my position is and why I think I should win. The main goal in the jury selection process is to find people that have no opinion about the case whatsoever and will be able to render a verdict based upon the evidence that is presented in the courtroom without going into the courtroom with any predisposed notion. So once we conference with the judge and we know the judge's schedule and the judge tells us our schedule, we begin arranging for our witnesses to come in, when they will testify and when the evidence is going to go in. Typically speaking, the trial is a process. The plaintiff goes first. The plaintiff speaks first during jury selection. The plaintiff puts on their case first. They put on witnesses first. If the defense chooses, they can do a cross-examination, but they don't have to. The plaintiff has to put on all their evidence, and when we are done, we rest. We rest our case, and if you've heard that expression by watching TV, movies, reading books, then the defense has an option to put on a case if they choose. They don't have to. Once the defense puts on their case, they will rest. Then the judge will have us do closing statements. That is the one time where the defendants get to go first and the plaintiff gets to go last, which gives the plaintiff some advantage because the plaintiff gets the first word and the last word. Then the judge will read the jury instructions to the jury. That is the law of the case. That is the law that the jurors must follow. They will be given a questionnaire to answer to decide who wins or who loses the case. When the jury is finished, they come back and there is a verdict. If one party is not happy with the result, they can file an appeal, and that is a whole other process. You have 30 days from the date of the entry of judgment to file an appeal in the case, to file a notice of appeal in the case, and then you have about 6 months to perfect that appeal if you choose. There has to be a reason to appeal. Either the judge made reversible error, or you think the verdict is too excessive or too low, but you have to have grounds for appeal. And then the briefs have to be due, and then eventually there's an oral argument, and the appellate division will decide. So there is a lot involved in retaining a lawyer in a personal injury case or any other matter. It can be frustrating, it can be long, but if your attorney tells you to trust the process, please listen. Any questions about personal injury cases, nursing home neglect cases, funeral home neglect cases, feel free to give me a call at any time at 1-855-Rizzuto or send me an email at PRizzuto@rizzutolaw.com. Happy to answer your questions. If I am unable to, I will point you in the direction to somebody that can. And if you found any of this useful, follow for more, check out my other videos, and I'll see you there.